Today, we have published a new edition of Insights for In-House Counsel, our regular roundup of legal developments affecting the UK business community. Our newsletter reviews recent developments and scans the horizon for future changes which may have a significant impact on your business, financially, operationally, or both. As you might imagine, this edition of our newsletter has been through several iterations as we've tracked the extraordinary events of the last few weeks. No doubt we're all hoping for a period of stability following the recent tumult in British politics, culminating in the appointment of Rishi Sunak as Prime Minister. Financial markets remain febrile, given the scale of the challenges we face in the wake of Brexit, COVID, the energy crisis, and the damaging legacy of September's mini-budget. But it is good to see that the markets have reacted positively so far, and that the CBI has welcomed Sunak's track record in steering the economy through difficult times. In fact, many of the proposed reforms we discuss in our newsletter were instigated during Boris Johnson's tenure. Sunak's full policy agenda will become clear in the coming weeks, particularly after the Chancellor's much-awaited autumn statement on 17th of November. But we expect that the need to regain confidence and stability will limit options for a radical departure from 2019 manifesto commitments. As many have commented, Sunak's new cabinet looks remarkably like Boris Johnson's, sending a message of continuity as well as party unity. This is welcome news for the business community. So what can we say about the new government's legislative agenda at this point? Well, while most of the measures in the Trust Growth Plan have been reversed, we expect the new government will need to explore other ways to support growth. Reducing the burden of regulation is likely to be part of the growth agenda. Not least to appease the ERG, Sunak will be keen to exploit post-Brexit regulatory freedoms. So the process of sweeping away EU red tape and designing regulation to suit the needs of the UK economy seems likely to continue. As noted in our newsletter, significant reforms are planned in several areas, including data security, competition law, consumer protection, and audit regulation, as well as financial services and public procurement. Regulatory uncertainty has dogged the UK business community for many months, and recent events have not helped. Therefore, the timetable for many of these reforms remains uncertain, given the hiatus in parliamentary business over the last few months. To help you keep on top of the latest state of play, we recently launched a regulatory reform portal, which is tracking the progress of the government's planned reforms across a wide range of topics. You'll find a link to the portal in our newsletter, along with details of how to sign up to our series of briefings on regulatory reform topics. Continuing with the theme of regulatory reform, however, the new Sunak administration is reported to be considering whether to press ahead with a specific measure designed to end the influence of EU law in the UK. Under draft legislation introduced by Jacob Rees-Mogg, the government will be free to reform or remove from the UK statute book, with minimal scrutiny, legislation derived from EU law. The EU Retained Law Bill contains so-called sunset provisions by which legislation will lapse at the end of 2023 unless replaced by new domestic regulation. The bill has been heavily criticised for creating significant uncertainty over which laws will be retained beyond 2023. And it's a target for campaigners who are keen to preserve certain workers' rights as well as environmental and other EU protections which are currently enshrined in EU retained law. But the Brexiteer and Rishi Sunak may be reluctant to shelve it altogether. Our newsletter reflects on the likely impact of the legislation for the UK business community. The new PM also inherits an immediate challenge in finding a negotiated solution to the current impasse in negotiations over the Northern Ireland Protocol. Many will be hoping for a reset, and Sunak is said to want to avoid a trade war with the EU, which would be deeply damaging to UK business interests. In other news, what news of the digital economy? With the EU's Digital Markets Act now in force, the law is beginning to catch up with the tech giants, and the UK will be under pressure to respond with an equivalent regime. Meanwhile, our newsletter looks at the risks and opportunities presented by the metaverse, in which many of the largest tech businesses are investing heavily, despite Meta's own well-publicised financial woes. Moving on to disputes, our litigators report that the UK's court system continues to be under pressure, as with so many public services, and our newsletter also considers the government proposals for mandatory mediation in small disputes, laying the groundwork for mandatory mediation in larger disputes to free up court resources for the cases where they are really needed. Whilst it may be some time before this becomes a reality, the direction of travel is clear. Our newsletter also looks at lessons from recent cases, including revisited the question of the duties of directors of companies in financial difficulty, a sign of the challenging times in which businesses are operating. And once again, the courts have recently been called upon to consider questions relating to misrepresentation, force majeure, and the doctrine of mistake. Finally, climate issues are returning to dominate the headlines as we approach COP27 later this month. Rishi Sunak is now expected to attend COP27, and we will be keeping a close eye on proceedings, looking out for commitments which signal the future direction of UK policy on climate issues. Meanwhile, the continuing rollout of TCFD and other ESG-related obligations for businesses shows no sign of abating. And we are closely monitoring trends in ESG-related litigation. This is of particular concern to large global corporates, given the recent landmark decision of the UK Court of Appeal to allow a group of Brazilian claimants to seek redress from BHP through the UK courts for losses relating to the collapse of the Fundão Dam in 2015. Our newsletter summarises these and other developments in the ESG agenda, with more detail to follow in our dedicated ESG newsletter in the next couple of weeks. These are just some of the highlights from the latest edition of Insights for In-House Counsel. There is much to digest, and we do hope you find it helpful. Rest assured that we are very aware of the challenges you face in the current difficult business environment, and we are here to help ensure that legal risk is not too high on your worry list. As ever, if you would like to know more, please do get in touch. Thanks very much.